Evictions can be very complex in West Virginia. That is why we are here to help. Welcome back, Loopers. It's Galena with DoorLoop. Today, we will be diving into the eviction process in West Virginia. It may vary from county to county, but for the most part, it's the same general eviction process. Send a clear written eviction notice, fill out the forms, serve the tenant, attend the trial, and wait for judgment. All evictions are different and depend on the lease or rental agreement signed by the tenant and the landlord. There's a need to exercise meticulous file keeping to avoid errors that could be exploited by the tenant. This video is a summary for landlords to use when evicting a tenant. It contains most of the information a landlord will need when they want to proceed with an eviction action. Remember, if you have any specific questions, don't hesitate to contact an attorney. There are some legal terms that may be tough to understand for a landlord proceeding with an eviction order for the first time. Get our guide to eviction laws on the go from DoorLoop's Landlord's Guide series. Click the link in the description. Now, let's dive in. Notice to quit. The notice to quit is a notice to the tenant that states how many days they have before they must vacate the property before being evicted by the court. Usually, the number of days associated with the notice to quit will depend on the reason for the eviction. However, during the West Virginia eviction process, landlords do not need to give the tenant any prior notice before proceeding with an eviction action, although they may give tenants a chance to resolve any issues should they wish to do so. In the state of West Virginia, a landlord can evict a tenant for multiple reasons, but they usually only need one. A lot of these factors rely on the lease terms stipulated in their written contract. The reason for the eviction can range from violation of the lease terms to the end of the lease. Non-payment of the rent and committing illegal behavior are both a violation of the lease terms. Landlords who wish to start filing for a West Virginia eviction lawsuit are given an option to inform the tenant that an immediate eviction is about to be filed, but it is not a legal need. The only time they need to provide written notice is if they are seeking to end the tenant's lease. No matter the reason for eviction, the landlord must not do a self-help eviction, which is a form of eviction that is against the law. Eviction reasons. Violation of the lease or rental agreement. In West Virginia, a landlord may evict a tenant for violation of the terms of the lease. The lease has to be upheld by both tenant and landlord for the entire duration of their stay. Lease and rental agreements may vary from tenant to tenant. Failure to pay rent. Landlords can evict the tenant for failing to pay rent in West Virginia. Rent is usually considered late a day past its due. If a tenant does not pay rent on time, a landlord may start eviction. Although landlords do not need to give the tenant a chance to pay the rent or provide prior written notice before filing for eviction, the entire eviction lawsuit stops the moment the tenant can pay rent and other due fees in full. Conducting illegal activity. If a tenant has engaged in illegal behavior within the property, a landlord may evict them. Examples of illegal activity are, but are not limited to, homicide, prostitution, theft, violence, assault, possession and/or firing of an illegal firearm, and involvement in the creation, distribution, or consumption of a controlled substance. A landlord must keep a close eye on their tenants to make sure illegal behavior does not go unnoticed. Non-renewal or termination of the lease after the rental term ends. The West Virginia eviction process states that landlords cannot force a tenant to vacate the property without a probable cause. As long as the tenant does not violate any rules, they can stay until the rental term ends. But if they stay in the property, even the day after their lease or rental agreement ends and have not arranged for a renewal, landlords must issue a written notice to move. If the tenant remains within the rental property even after the date of the notice has passed, the landlord must continue filing for eviction. If you want your own West Virginia lease agreement, head over to DoorLoop's forms page and click the link in the description to download your very own template. Filing a complaint. How to file a complaint. The West Virginia eviction process can only begin after the issuance of the appropriate written eviction notice. Enough notice time must have been allowed before filing for eviction with the court. However, since no notice is required for most evictions in West Virginia, the landlord may file for an eviction lawsuit directly. The eviction process is as follows. Proceed to the justice court the rental unit belongs to, file a complaint, and pay the fees. Timeline. It takes about 7 to 90 days from the issuance of the notice to quit in a West Virginia eviction before a landlord can start the eviction lawsuit. Notice to comply. Before filing for an eviction with the court, you need to issue the tenant a notice to comply. You can either download the free PDF or Word template or create your West Virginia eviction notice by clicking the link in the description to use a step-by-step wizard that guides you through the entire process to make sure you are submitting the legally correct notice. Keep in mind, the step-by-step wizard will ask you to pay a small fee at the end. It's a small price to pay to ensure legal compliance and protection. The last thing you want is to go to court only to find out you did the first process incorrectly. Serving the tenant. How to serve a tenant. According to the West Virginia eviction law, anyone over the age of 18 and is uninvolved in the case must deliver the court order, also known as the summons, for the eviction hearing and the complaint to the tenant. There are several methods available. Personal service. The server delivers the summons and complaint to the tenant in person. Substituted service. If the tenant is unavailable, a copy of the documents must be left with the member of the tenant's family. Mailing. The server mails a copy of the documents via certified mail. This method needs a return receipt. Publishing. The server publishes a copy of the documents via the local paper. The summons and complaint must be served to the tenant within 120 days from the date the complaint was filed by the landlord. The landlord has to show proof that the tenant has received a copy of the documents, usually via return receipt. After serving the summons and complaint, a tenant is not required to file a response, but if they want to, the tenant must file one within 5 days of receiving the document. Asking for possession. Filing a motion to obtain judgment and get a judgment for possession. The landlord has to provide a strong argument backed up by solid evidence against the tenant. Should the tenant fail to show up to the hearing, the landlord wins by default. Next procedure if the tenant disagreed and replied. In the state of West Virginia, a reply from the tenant is not necessary for the court date to be scheduled. However, the tenant must show up to the hearing. If the eviction hearing is scheduled for a magistrate court, either party could request for removal of the case to the circuit court. This only applies if the total amount racked up by the rent and damages goes beyond the set dollar amount. The landlord needs to support the claim with evidence and show it during the hearing. This could include, but is not limited to, the following: copy of the deed and lease, rent receipts and ledgers, bank statements, witnesses, and photo and video documentation of the violations, correspondence, etc. Should judgment be passed in favor of the landlord, the tenant can file an appeal, but if their rental term has already expired, they will not be allowed to stay within the rental unit while undergoing an appeal. Even if the tenant wins, the court may decide that they can't stay in the rental unit. Timeline. Eviction hearings in West Virginia are scheduled on a date that is 5 to 10 business days after the landlord requests for it. An additional 7 to 10 days is added to the original date if either party requests a removal of the case from magistrate court to circuit court. Getting possession. After the landlord wins the case. Provided that the tenant does not appeal for reconsideration, the judicial officer will decide when a tenant must move out of their rental unit. Should the tenant remain in the rental unit after the indicated date and time period set by the judicial officer, the landlord may return to court and request for a writ of possession. However, there may already be a sheriff assigned to remove the tenant from the property. If this happens, no writ of possession is required. The writ of possession is an official court order that gives the sheriff the right to forcibly remove the tenant from the property. Without it, law enforcement cannot remove the tenant through legal means. Move out process. A tenant must move out by the time period given by the judicial officer. If they fail to do so, then the court order requested by the landlord will allow the sheriff to forcibly remove them from the property. This could take a few hours to a few days depending on the availability of the sheriff and on the type of eviction case. Even though a landlord has won the trial, they are still not allowed to use illegal methods of eviction. The state of West Virginia specifies that if any personal belongings are left behind, landlords are advised to contact the tenant and give them 30 days to claim them. After the time frame has passed, the tenant's property may be sold or disposed of without being held accountable. There's no court order necessary. West Virginia eviction process timeline. Below is the average timeline for the complete eviction lawsuit in West Virginia. This timeline does not include special cases such as requests for an appeal or continuance. Showing evidence. How to keep good records. If a tenant disagrees with the eviction request and they reply to the court, it's important that you keep extremely good records of everything so you can provide proof to the judge and win your case. This part can make or break your entire eviction request in the event of a dispute. You can stay organized by keeping a physical paper trail. This gets very hard to search through, takes up a lot of storage space, and could get lost, damaged, stolen, or burnt in a fire. Scanning documents. Scan every document into your computer. Backups. Store and backup every file using Dropbox, Google Drive, OneDrive, or any other option that is easily searchable. PMS. Use a property management software to save everything from lease agreements, signed documents, violations, emails, notes, invoices, payments, reminders, maintenance requests, pictures, videos, and anything else that can possibly be useful in a court case. This is used best when you also scan every document into your software. Evidence to show for not paying rent. If the tenant doesn't pay rent and they dispute that claim, it's important that you show the judge the following: your lease agreement, showing the terms of the agreement, when rent is due, and any penalties for late payments. All payments, showing all previous payments, how they were normally made, check, credit card, ACH, etc., and what date they were normally paid on. Any payment returns. If their check bounced, their bank account had insufficient funds, or they did a chargeback dispute on their credit card, show this to the judge. Also show any fees your bank may have charged you and any penalties you are owed according to your lease agreement, in order to be covered for any unnecessary charges that you may have faced. All messages. If you sent your tenant automated or manual payment reminders by text, email, letter, or mail, it's important to show these. While it's usually not needed, it's still good to show that they were aware of the situation and were given time to cure and make the payment. This is why it's always best to have everything in writing instead of any phone calls or face-to-face meetings. Evidence to show for lease violations. If you're evicting the tenant for lease violations, for example, noise complaints, unauthorized pets, or property damages, it's important to show proof from any of the following methods. Security cameras. If you have a surveillance system that can show them committing the crime or lease violation, it's safe to say you will normally win this dispute. Video. If you didn't catch them in the act, the next best thing is to record a video with your phone of any damages of the lease violation and show this to the judge to prove the violation. Pictures. They say pictures are worth 1,000 words. In this case, a picture could be worth thousands of dollars. Even if you take a video, it's important to show the judge any pictures too, as it's usually easier to see by email or printed. Lease terms. Once again, show the court which term they violated in their lease agreement. Don't worry if you don't have every single term spelled out in your rental agreement. If the violation is bad enough, it might not be needed to have it written. As a good practice though, start adding all of the potential reasons to evict a tenant into your agreement. Before I go on to talk about self-help evictions, don't forget to like, comment, and subscribe for more amazing content. Self-help evictions. Examples of illegal self-help evictions include changing the locks, taking the tenant's belongings, removing the front door, or turning off the heat or electricity. Many states specify how much money a tenant can sue for if the landlord has tried to illegally evict the tenant through some sort of self-help measure. Some state laws also provide for tenants' court costs and attorney's fees if the tenant successfully sues the landlord, and/or give the tenant the right to stay in the rental unit. Thank you for watching this video. For more valuable content, join our exclusive Facebook community with the link in the description. And to learn more, feel free to check out these videos. Thank you and have an amazing day.